So hello everyone again, dramatists, DG members, friends of dramatists and DG members. We are thrilled to have you back. If you've been joining us this week for our programming celebrating National Estate and Legacy Awareness Week and you've been with us before, welcome back. If it's your first time, happy to have you here. My name is Deborah Murad. I am the Executive Director of DG Copyright Management. And we are really honored to have brought you this week's programming on estate and legacy planning. And we are at our final panel, Celebrity Mistakes in Estate Planning and Estate Planning for Dramatists, What Every Copyright Owner Needs to Know. It's a 2-for-1 today. We have two incredible attorneys and attorney/accountants with us. So I can't wait to jump into that. Just really quickly, for any of you not familiar with DGCM, we were formed by the Dramatists Guild a few years ago to manage works that were bequeathed to the Guild and its related organizations. And we're a different type of management organization because unlike other agents or publishers or executors who might be solely concerned with maximizing revenue, our primary objective is authorial intent. That is your intent. And we aim to have the author's intent guiding our work and our decision making. We collect statements of authorial intent, and we are very, very fortunate because we are also have a subcommittee of the Guild Council, so a committee of the top composers, lyricists, playwrights, librettists of the time making those difficult authorial decisions on the author's behalf when needed. So if you're looking to give back for the Guild, want a place to leave your property, want to talk it through, we have an info session at 6 o'clock this evening on Zoom, but you can always reach out and call us. I will be putting all of our contact info in the Zoom, so you can always know how to reach out to us. But if you've been with me this week, you'll know that what is most important is not that you enroll with DGCM, but that you have a plan, for your songs, for your plays, for your lyrics, for your musicals, because they are like your children and you have to care for them. You have to nurture them and make sure that they're protected for their full term so that they can be celebrated for their full term. And that's very much how artists live on. So that's our theme for the week. Let's get a plan in place. We started off this week talking about estate planning, and now we're right back into the thick of it to explore some of the tangible do's and don'ts and to further understand how copyright really does intersect with estate planning. This is really a culmination of the entire week, so I'm sure you're going to have lots and lots of questions. I'm going to ask that you use the Q&A for any questions. The chat has been turned off, so you shouldn't be able to chat in it, but if for whatever reason you are, please put your questions in the Q&A so we don't miss out on those. And just a general caveat here that all the information you're going to hear is for your informational purposes. You should take that and bring it to your attorneys and your accountants and your personal team to discuss all these things. Neither of these gentlemen are your attorneys. They're just providing you with some information so that you can start to ask the right questions. So, interestingly enough, this panel came about because I was trying to learn more about estate planning and copyright ownership, and there was really nothing out there for all of you, for dramatists, until I came across this article written by Ronald Finkelstein and Lloyd Jasson. So I'm going to introduce them really quickly. Ronald Finkelstein, he's a tax partner at Markham Accountants and Advisors. He's also the co-partner in charge of the Trust and Estates Practice Group there. He has extensive experience both as an attorney and as a certified public accountant, and really helps his own clients make informed decisions about their futures, about their families, about their businesses. He handles all aspects of trust and estate administration and is a real recognized authority on trust and estate issues. You'll see him quoted throughout media if you Google him a little bit. He's also lectures quite often on the topic. And then we have Lloyd Jasson, who is no stranger to the Dramatists Guild. He's a publishing and entertainment attorney and head of his own boutique firm. And he counsels rights holders, creators, writers, composers, agents, producers, publishers, basically everyone in the industry on a full range of issues: libel, trademark, copyright matters, advising about copyright terms, termination of grants, He's a whiz at all that. You'll see that soon. He's also quoted extensively throughout the New York Times, Washington Post, Fortune, Forbes, other publications, speaks extensively. He did go to Cardozo Law School along with myself and our executive director at the Guild, Ralph Savage. So I thought that was pretty cool. He is actually also the co-author of the Copyright Commission Libel Handbook, which I understand now is being revised. So if you're looking for a good resource, you could always check that out, or check out the new version, I guess. And with that, I will pass the baton over to Ronald, who's going to start us off, and we'll take questions at the end. So just keep them rolling in the Q&A. Thanks.
Okay, thank you, Deborah. So Deborah introduced me just a little bit quickly about the firm. The firm has been around since 1951. When I started, it was a small firm of 150 people. Now we're over 2,000 people with offices throughout the country. But the one thing that I want to point out about the firm is, coincidentally, that when the firm started and there were 5 people in the firm, they had a significant number of authors that were clients of the firm. And they still are clients of the firm. I can't really mention the names, but I currently represent one very well-known living author. I represent an estate of a deceased author that's still going on and collecting royalties. And I guess the one that I can mention, because it's out there, is that the CEO of Markham is also the executor of the estate of Robert Ludlum. So, obviously we do some work for the estate of Robert Ludlum. And as you'll see from my presentation, I'm going to really talk a little bit about estate planning and why we need to do estate planning. I'm going to go through some examples of people, celebrities that didn't die with wills and what we can learn from that. And then talk about appraisals of literary works and literary property and what goes into those types of appraisals. But the interesting thing about Robert Ludlum is Robert Ludlum died with a will. And Robert Ludlum did obviously good estate planning, and he named an executor to exploit his property. And the CEO of my firm, quite successfully, went to the grave and put a pen in his hand and had him write several novels posthumously. So as you can see, there are a lot of things that came out from him after he died. So there are, with good planning, good opportunities for your literary executor to continue to do to exploit your works for a long period of time post-death, and to develop work for your royalties and money for your descendants. So with good planning, that's always a good thing. And you'll see in some instances that if you don't want your work exploited, if you don't make the proper plans, you're going to come into issues with that as well. So with that, I'm just going to go through briefly a little, and we can see the slides, right, Deborah?
Yes, we can.
Okay. So what I'm just going to go through briefly is, estate planning. And since it is estate planning week, we need to all, a lot of people are rushing now to do some estate planning, especially high net worth individuals, because the House Ways and Means Committee has come out with a tax proposal where they are looking to make changes within the estate and gift tax area. And one of the big changes would be to reduce the exemption amount down from its current amount of $11.7 million per person, which is the amount you can give away estate and gift tax free to your heirs, to somewhere down around $5.85 million. So that, under the proposal, is effective 1/1/2022, and people are looking to move quickly so that if they can afford to make those gifts, they do it now before they lose the opportunity and the exemption goes down. The other changes that are in the proposal are changes with respect to lack of marketability, minority discounts, and the use of grantor trusts. So a lot of high net worth individuals are doing planning today in order to not be stuck and locked in by some tax proposals that may go through shortly. And some of these changes are actually effective as of the date of enactment of the statute, which could be at any time. So right now the exemption is pretty high at 11.7 million. And if you're a married couple, then each of you have $23.4 million of exemption. So as the law stands now, there are not very many people that are subject to the estate tax, but you still need to do planning and have documents in place, which I'll talk to as well. But if the exemption goes down to the 5.585 million, then a lot more people will be subject to the estate tax, and the need for more people to focus on estate planning is more relevant. Also, when you're over the exemption amount, the estate and gift tax rate is pretty much a flat 40% on the fair market value of your assets, less any allowed deductions and debts. So the estate tax rate is pretty high, and therefore, the need for planning, if you're going to have a taxable estate, is pretty important. Everyone can give away $15,000 per year to any beneficiary without using their annual exclusion of their lifetime exemption amount. There is portability, which I'm not going to get into, but there's a slide here on that. But basically, it allows you to leave all your money to your spouse without losing your spouse's exemption amount. So if one spouse were to die and leave everything to the surviving spouse would have, the $11.7 million of exemption times two, because he would get the first spouse's to die exemption through portability. And when we're looking to do estate planning techniques, the fact that the interest rates are very low is very helpful in going ahead and doing planning techniques and having them be successful. So if you need to do planning, now is definitely a good time to look into good planning opportunities. There are a couple of slides that talk about estate planning and the need to do that. But the key thing about estate planning is that when you give away assets today, and the longer you live, you're giving away assets at today's value. And when you give them away, the assets are out of your estate. So all the appreciation that will inure on those assets that you would have held on to until your death will be out of your estate. And if we figure out what that appreciation would be, that over a 10-year period of time, that could be a substantial sum of money given whatever growth there is on those assets. So the earlier we do plan to get appreciation out of our estate, the better off we are. And these are just some examples how using the interest rates that we're allowed to under the current IRS tables, that we can get a lot of appreciation out of our estate. You can also take advantage of discounts. So certain assets, because we own a minority position or the assets are not readily marketable, they can be subject to discount planning as well. So if people were to contribute royalties into an LLC, and assuming we could do that, and give away, a fraction of that, we can use discounts for a lack of marketability and lack of control because they're part of an LLC, and the LLC is not necessarily a marketable vehicle if there is an operating agreement that restricts transferability and things like that. Okay, and here's some just discount examples of how using a discount will help in further reducing your estate if we can apply discounts for lack of marketability and minority interest. So I'm not going to go into these. I think it's just going to, you can read through them. But if we can do discount planning, that would be good as well, because it allows you to take something that is worth $1 and really give it away using only like 60 cents of your exemption, because you put it into an LLC or some type of restricted entity, and therefore what you're giving away is not marketable, and you have no control over it because it's controlled by the people that have the voting units or the majority interest in those entities. So there's a lot of good planning out there to take advantage of if you're in a position where you need to do so. So let's move into the next facet, which is to look at what mistakes certain celebrities made by not having a will or not doing proper estate planning, or they did its proper estate planning, and what the benefits of that were. So the first example would be Prince. And, I don't think it's really clear what Prince's estate was worth, but there were some reports that it could have been worth as much as $300 million. So pretty substantial estate. It doesn't look like he did any estate planning during his lifetime. He died when he was 57 years old, and he was survived by 6 siblings. Some of them, I think, were half siblings or half sisters or full siblings, whatever. But those were the people that would have inherited his estate because he died intestate. But by not dying with a will, he missed out in the opportunities to do various types of planning. And the key thing, we'll just skip to the bottom because I think this is most important to people that have intellectual property, is that he lost out on the ability to determine how his works would be handled after his death. So if we had a will, then he could have named an executor and a literary executor and set up trusts and name trustees, and that would have given the ability to have the people that he wanted to handle his estate and do the necessary tax filings and collect the assets and distribute them in accordance with the terms of his will. But most importantly, with respect to the intellectual property, it would have allowed the executor to dispose of or to exploit his intellectual property in the way that Prince was most comfortable doing. Now, just from what I remember reading, and I haven't read that recently, but I'm pretty sure that he had a lot of unreleased works, and I'm not really clear whether after he died, he wanted those released works exploited and out in the public, but I'm pretty sure that those things are going to come out if they haven't already. And that may not have been what Prince wanted if he had left a will and he had clearly laid them out in the terms for a literary executor. So by not leaving a will and doing what he could have done, he's left to the control of whoever applied to be the administrator of his estate, which I think is one of the siblings, to do what he or she wanted to do or thought was best interest to do with the intellectual property. So very important that we focus on having a will, and we'll go through some of the provisions that you can put into a will to name a literary executor in a few minutes. The other thing that people lose is that they lose the ability to set up trusts and leave inheritances in a trust for the benefit of their beneficiaries as opposed to outright. And the trust has a couple of features that are very important. The first is that if you inherit assets in a trust, is that you have creditor protection on those assets. So to the extent that you get sued by someone, could be in business, could be someone falls on your property, car accident, and you don't have adequate insurance coverage, and you're personally liable, they can go out after assets that are in your own name. But if the assets are in a proper trust format, then they are, in most states, I'm pretty sure all states, protected against creditors' rights. So having a trust for that purpose does have a lot of benefits. And the second thing that's important is that you could have in some way reduced estate taxes. So by putting assets in a trust, then upon the beneficiary's death, those assets would not be subject to estate tax because the beneficiary didn't have absolute ownership. They just had beneficial ownership because they were a beneficiary of a trust. And being a beneficiary of a trust will keep the assets out of their estate for estate tax purposes, and will allow more money to pass to their heirs upon the sibling's death. So there are a lot of good planning opportunities that Prince missed out on by not dying with a will. Aretha Franklin, very similar, had children when she was very, very young. She died at 76 years old. Her estates were reported to be somewhere between 60 and 80 million, and she was survived by 4 children. She also did not leave a will, and therefore had very similar issues that needed to be addressed that she could have controlled if she had left a will and specified that in the will document. Most notable, again, would be the exploitation of her intellectual property and what she wanted to do with that and how it should be exploited after her death. Now she's up to whoever was appointed as an administrator, up to them to take care of that. Again, she lost the opportunity to set up trusts and to save estate taxes by reducing the estate tax on those inheritances when her children died, and more assets could pass to their children free of estate taxes on their death. Also, creditors and rights, as we just discussed. And again, when you inherit assets in a trust and you get divorced, those assets are not subject to equitable distribution. So in a divorce, they would not be available to split up with a spouse. So again, lots of benefits of setting up trusts and doing planning with trusts. The next example is someone who died with a will and did the right thing. And so we don't have anything bad to say about David Bowie. He died at 69 years old. His estate was worth reportedly around $100 million, and he was survived by his wife. I think his wife was Aman. I can't remember. I think so. Model. And he had a child from a prior marriage, and he had a child with his current wife. And so what he did was he left 50% of his estate in trust for his wife. He left 25% to his older daughter outright, and 25% in trust for his younger child. And not only did he have the ability to control the exploitation of his intellectual property after his death, because he had a will that I'm sure had provisions in there to protect it and to give the executor specific provisions as what he wanted to be done with it. But by leaving his wife's share in a trust, not only did that generate estate tax savings and benefits for that, because that inheritance would not be taxable until the wife died, but it would ensure that upon the wife's death, that the property went to his children, because that's what he wanted it to do, as opposed to giving it outright to his spouse. And then his spouse had control as to where those assets got disposed of. So a lot of good planning when you leave a will, set up trusts, and name a literary executor. Whitney Houston, she died at 48 years old. Her estate could have been worth, we're not really sure, but could have been pretty substantial. She did sign a will back, I think, in 1993, before her child was born. And her estate went in trust for the benefit of her child. I can't remember her name now, but Bobby Christine, I think. And the trust was payable to her at age 30. The daughter died at age 22, so that was not a good thing, obviously, but because the assets remained in trust, they were able to pass and not be includable in the daughter's estate, and went to the next generation free of, possibly free of estate taxes, because it was not includable in her daughter's estate. But should her daughter have lived past the age of 30, then the assets would have been includable in her daughter's estate and subject to estate tax. And if her estate was $115 million, after whatever state taxes Whitney Houston paid, there would have been a substantial inheritance that would have been subject to estate tax on her estate. And she would have benefited by the fact that she could have had a trust that went either for her daughter's lifetime and therefore to the next generation, and gone for a longer period of time, and had some better estate tax savings benefits. So what documents does everyone need to make sure that they're in good shape for estate planning purposes and the disposition of their assets? Well, everyone needs a will, and we just talked about why in some respects. Everyone should have a healthcare proxy so that if, God forbid, they get into some sort of accident and they need to, they can't make decisions on their own. The decisions are known to their healthcare agent, and they can make these life and death decisions for them. They should have a power of attorney in case they are incapacitated and can't sign their own checks and manage their own affairs. And by having a power of attorney, it alleviates the need for going through a conservatorship or guardianship proceedings. And for this group of, most importantly, you want to have literary executor appointed and specifically outline the provisions that a literary executor needs to address. So these are some of the powers that a literary executor would have spelled out. I'm sorry, this would be in a will for the literary executor to follow. They're pretty broad. To collect all royalties, income, and proceeds from the use and exploitation of copyrights, to negotiate, arrange, and contract for the publication anywhere in the world for copyrights, to renew existing copyrights, to employ, retain, and pay brokers and agents, and to help, manage what you need to do to deal with copyrights in the same way as if you own them in your own name. So these are good provisions with respect to literary executors that you should include in your will to make sure that the literary executor is clear as to what needs to be done. So again, Prince didn't have a literary executor, and if he didn't want some of his rights, royalty, intellectual property exploited after his death, because he didn't think they were of good quality and he didn't want them released, he certainly could have added them into his will and let his executor and literary executor know of that so that they would not be released. So very important to have those documents. If you need to do estate planning, we talked about that as well, and to have literary powers in your will so that the literary executor is aware of what he or she needs to do. And don't make the mistakes of dying without a will and not having your beneficiaries adequately protected and your royalty interest in intellectual property protected. The last thing I just want to speak about is how intellectual property is valued in your estate when you die. And basically when you die, you need to have appraisals of your assets at the fair market value, which is what a willing buyer, not related to you, would pay for a willing seller. And so you have to go out and get an appraisal of of whatever intellectual property you have. Basically, the valuations are done based upon historic royalties and trends. Many authors or playwrights receive advance payments or upfronts, and therefore that money is usually collected. And to the extent there's a royalty stream associated with that, then there'll be some sort of cash flow analysis to determine what future income will come into your estate and needs to be included in the valuation. Often they'll take into account expenses that need to be incurred by the estate, such as for tax preparation and literary agent fees. And if there are works in progress where there's still writing and editing to be done, then those items will be taken into account as well. The discount rates, because you're coming up with a present value, are not very high like they would be with other assets, because the contracts are pretty steady and guaranteed and going to be paid. So there's not a lot of risk involved. So the discount rates are not that high with respect to other types of assets. The key thing that you need to know is, well, what happens if you die with works in process? And, what happens there? So then again, there may be costs involved in the appraisal to hire a ghostwriter to finish it up and to account for the streams of income that could come in with respect to that. When we're looking at valuations, we pretty much look and see what is, trying to get the words here, known and knowable at the time of death. So if we have a movie which is known or knowable at the time of death, or a book that is known or knowable at the time of death, or some sort of royalty stream or something that's known or knowable at the time of death, then these things will be included in evaluation of the fair market value of the intellectual property for estate tax purposes. But if they're not known or knowable, then they're typically not includable in the appraisal. So again, going back to Robert Ludlum, I don't think it was known or knowable that there'd be all these Bourne movies and that there'd be other books written after death. I'm not really sure if there were any contracts in place as of his death. So that obviously, the valuation did not reflect a lot of income and money that was generated post date of death. Michael Jackson, there was a lot of controversy and IRS cases with respect to his likeness and his image and the valuation of that and how that can be exploited. So valuations are very subjective, and they're often can be challenged by the IRS, and they'll bring in their own valuation people to determine what something may or may not be worth, and you have to go and fight that. But if things are not known or knowable, then they probably won't be includable in the valuation. And there are a lot of things that you just can't see in the future. For instance, Tom Clancy, I think there's a Netflix series someone just mentioned to me about Tom Clancy's works. I don't think Netflix was even around at the time. So, those things are not known or knowable and not includable in the valuation. So, if you draft the will and give the literary executor the authority to exploit your work, you can continue to make money, and a lot of that won't be captured in the valuation because things will happen post date of death that are not known or knowable as of the time of death. So with that, I'm going to wrap up.